This is Scott Pierce. Today's seminar covers real property, everybody's favorite topic on the bar examination. The good news is, real property is much more difficult on the multi-state than it is on the essays. The bad news is, it's still real property, and it still has a lot of difficult, complicated issues to contend with. Also, on the essays, it's worth noting up front that real property is almost never tested by itself. It's almost always tested with one or two other subjects, notably remedies, torts, and contracts. And by the time you're done with this seminar and the remedies seminar that follows it, you will understand that far better than you do right now. Let's take a few minutes and review an approach to real property. You'll note that I begin with a minimalist approach, trying to give you the big picture up front. I think there really are only four big clusters of issues in real property. And they are land ownership, land use, landlord-tenant, and remedies. And up front, I can point your attention to ways in which each one of these broad topic areas crosses over into other subjects. Land ownership can cross over into contracts, it can cross over into wills and trusts, and it can cross over into community property. Land use can cross over into constitutional law with regard to government regulations of land use and the Fifth Amendment takings issue. Landlord-tenant, by its nature, is a crossover into the law of contracts. And remedies, as always, brings all of the different subjects together, as we're going to see. So, let's consider a somewhat more elaborate approach to real property. As we work on essays, our first job is to identify the pocket area, or areas, being tested, and then to remember the basic content of each pocket, so that we can find a home for the facts in an appropriate framework of legal analysis. So let's get into the elaborate approach and focus first on land ownership. Many of you who are really good at real property, or at least were in law school, may have some elaborate approach to adverse possession in your mind, one that may have 5 or 6 or even 7 elements. And if, as you sit there watching this video, you can remember those elements, go ahead and use them. But if adverse possession has been somewhat confusing or complicated for you, as it always was to me, then a stripped-down approach can help you really get to the point on adverse possession. For bar exam purposes, it is okay to consider adverse possession in a 3-step approach. The mental element, what we would typically call the hostility aspect of adverse possession, the physical element, the actual occupation of land, and then the time element. Has the claimant occupied the property with the right intent for long enough? And this 3-part approach to adverse possession actually has made it into 1 or 2 answers that the bar itself has published. So we know that it is an acceptable, if somewhat stripped down, approach to adverse possession. Next, in land ownership is that part of law that most people really fear and despise in real property, estates and future interests. And here, the multi-state really is a lot more abusive than the essays. The essays rarely test future interests, but when they do, it's in a fairly clear-cut, straightforward fashion. So what you need to have in mind is a very quick, short checklist that connects the various estates to the future interests that they're connected to. And that's what I've tried to do here in the elaborate approach on land ownership. Notice that I indicate 5 estates, and I connect each of them to the future interests that apply. And if you look carefully, I think you'll see that I have done a fairly complete job. This is an effort at a comprehensive approach to future interests in the absolute fewest words. So let's have a look at it together. We know that the primary estate is a fee simple absolute, total ownership, and there's no future interests involved at all. Next we go to a fee simple determinable. This is subject to the future interest known as a possibility of reverter. A fee simple subject to a condition subsequent, a allows the grantor the right to re-enter. Next, a fee simple, subject to an executory interest, has two different potential future interests. A springing executory interest between grantees, a shifting executory interest between grantees, and a springing executory interest from the grantee back to the grantor, and then to a new grantee. And then, finally, a life estate, which is connected to a reversion or a remainder future interest. Next, under land ownership, we consider concurrent ownership. This is where real property crosses over most directly into community property. A joint tenancy where each tenant has an undivided interest in the whole, a tenancy by the entirety, which is a joint tenancy by a married couple, and this is a fairly antiquated form, and tenancy in common, where each owner has a separate share of the property. Next, in land ownership, we consider land sale contracts and mortgages. And as most of you know, mortgages are, and have been, a fairly hot topic on the multi-state for some time now. Here, contracts and mortgages really are a part of contracts law relating to real property. And of course, in contracts law, these would be common law contracts. Next, we consider deeds and conveyances. Here, we need to be aware of various small internal checklists, and when we get to our seminar questions, I'm going to fill in more details on these details. But remember, the big picture here is, in order to establish a claim of ownership by deed, the plaintiff has got to show a valid deed, delivery, and good title. So, under deeds and conveyances, we talk about the deed formalities, the recording acts, and equitable conversion, who bears the risk of loss during the escrow period. Next, we consider possessory rights relating to land. Here the material crosses over directly into torts. Here we are dealing with water rights, lateral and subjacent support, and waste, nuisance, and trespass issues. Land ownership really takes up the bulk of real property issues. Next, we turn to land use. Here, we deal with easements, covenants, and servitudes. This is very difficult law. At least most candidates find it to be so. And on the essays, sadly, it's pretty tricky. We'll take a look at some complicated issues here, and I think you'll see that even though these are difficult issues, once you understand how they're tested, you will find them drastically less difficult. Next, we consider licenses, which always are revocable unless coupled with an interest or unless executed by reliance. Next, covenants and servitudes, and then finally land use regulations. Here, as I indicated earlier, we're dealing with material that is intrinsically connected with constitutional law. Here we're dealing with balancing the police power against private property interests. Also, eminent domain is present. And given the amount of action that this issue has seen at the U.S. Supreme Court in recent years, I think we can always expect land use regulations to show up without being at all surprised. Next, we consider landlord-tenant law. This is extremely commonly tested on the essays, and you're going to see these issues more than once in our work together. With regard to landlord-tenant, my first caveat for you is to remember that this is really part of contracts law as it relates to real property. And there are several different types of tenancies. I list them for you here in the approach, and I don't see any reason to read that list. But please realize that there are different types of tenancies, and the rights and obligations of the parties are a little different within each one of them. In landlord-tenant law, there's a number of disputes arising with regard to the condition of the property. We're dealing here mostly with waste and with fixtures. Here you're going to see that the law is tested in much more detail on the multi-state than here on the essays. But the core information does come up on the essays, as you're going to see. Finally, assignment and sublease issues are relevant in landlord-tenant law, and they're also commonly tested. We're going to have a look at these issues more than once also. Finally, remedies wraps up the subject. And don't forget, remedies is the heart of every bar exam in this country, as they should be. Remedies allows us to reach conclusions to indicate who wins, and if they do win, what they get. And we've already looked at remedies twice together in torts and in contracts. All of those remedies issues are fair game here in real property. Just remember the big picture of remedies. It includes damages to make the plaintiff whole, restitution to prevent the unjust enrichment of the defendant, and equitable relief, specific performance in contracts, and equitable relief in torts. Both of these sets of equity issues commonly are tested in questions involving real property. And then, finally, defenses to remedies. These are the same in real property as they are elsewhere on the exam, as you will soon find out. Well, that wraps up a consideration of an approach to real property. It's a tough subject, but an interesting one.